is Megan Spring, and I am the first Justice of Marlborough District Court.
Why did you choose your career?
So that's a good question. I've wanted to be a lawyer since I was 10 years old, and we studied the American Revolution in school. I couldn't believe that the colonists were presumed to be guilty and they had to defend themselves. You weren't entitled to an attorney. The government could regulate your speech, and there was nothing you could do about that. So when the colonists came here and the revolution occurred and there was the Constitutional Convention, there were a lot of conversations amongst the founding fathers about sort of our fundamental rights and what they wanted to do about that. So I thought that was really interesting. And then when I was in 6th grade, I read To Kill a Mockingbird, and that became one of my favorite movies. So that's why I wanted to become a lawyer. I didn't know what kind of law I wanted to practice when I went to law school, except public interest law. So I went to Northeastern Law School because it has a focus on public interest, and they have a co-op program. Law school is generally 3 years long for everyone all over the country whenever you go. So in the first year is mostly the same for every law student. But at Northeastern, after that, you get split into 2 groups and you start doing co-ops. So every semester, you're either in school learning or you're out of school somewhere in the legal community, and you can choose where you want to be. So my first co-op was with Judge Coven, who at the time was the first Justice of Quincy District Court, and I just fell in love with District Court when I was there. And it's funny now because he's one of my colleagues. He just retired, but he's a recall judge, so now I work with him in the District Court. And then after that, I went to a plaintiff's firm, which is the civil side, and I thought it was interesting, but I didn't love it. Then I did a summer associate at a big firm in Boston, which everyone wanted to do, and I thought that would be really cool, and that's what a bunch of the TV shows are about, and you make a lot of money, and I hated it. It just wasn't for me. We spent a lot of time doing what's called document production, which is people subpoena other people when you're in a civil suit, and then you look through all the documentation, and then you have to keep notebooks about what it is, and then you prepare other lawyers for the depositions, which are just long conversations with witnesses in the case, and to me that was really, really boring. And then my 4th co-op was with the Middlesex DA's office, and under a rule called 303, you can practice when you're not a lawyer yet, as long as you're supervised by another lawyer and you are enrolled in law school. So I went to the Newton District Court, and my supervisor let me try a bunch of cases and do bail arguments, and then I said, okay, this is what I want to do when I graduate from school. When I graduated from law school, I became a Superior Court law clerk, which was a really good decision, I thought, because I was able to work with Superior Court judges. There's a lot of reading and writing, and then you're in civil sessions and criminal sessions. So it was there that sort of cemented my non-love of the civil world and really being interested in criminal law. So that lasts for a year, and you can re-up for a year, or you can move on to another job. So I applied to the Middlesex DA's office, and I became an assistant district attorney. And I started that job. I was up in Lowell, and then I supervised Somerville District Court and Cambridge District Court, and then I got promoted to Lowell Superior Court. And I loved that. But while I was there, I had a really great judge named Michelle Hogan. She was in Cambridge District, and I was on what was called the trial team at the time. So I tried hundreds and hundreds of jury trials in front of her over the course of about 18 months. And she would give me good feedback after. And just learning from her, I realized I would be better in the middle than on one side or the other. I got married in 2007, and then my husband and I had a baby, and he was in the DA's office too. So he left to go do insurance defense, which he didn't love. So he hung a shingle and became his own criminal defense lawyer. And then at the time, the DA's office is a public interest. They don't pay a lot of money. And so our cars were disasters, and he had holes in his shoes. And I just said to myself, it might be time to leave the DA's office. So I went to private practice with him. And then I became a Superior Court, an assistant clerk magistrate in District Court, in Lowell District Court. And then I applied to be on the bench. So I knew I wanted to be a judge, but it's kind of a convoluted path to get there. You have to be nominated by the governor, and then you put in an application beforehand. There's a long application process. You get interviewed by what's called the Judicial Nominating Committee. Once you make it past that interview, you go into another pool where they do what's called due diligence on you, where they call pretty much anyone you've ever tried a case with or interacted with. Then they do a deep dive into your financials, and then you meet with the governor's chief legal counsel and the head of the JNC and they interview you. And if you make it through that, you go on what's called the slate, which is a group of people that they've approved for the governor to pick. And then the governor nominates you, and then the governor's council has a confirmation hearing. And then that's, if you get at least, I think it's 7 votes there, you get sworn in as a judge. So I attended American University. I studied political science and economics. I wanted to go to school in DC because I thought that I wanted to maybe go into politics. And there, I was in the School of Public Affairs, so a lot of us ended up going on to law school. And I had great internships there too. I interned on the Hill, I interned in the White House. I had a lot of great teachers who were who either worked on the Hill or were lawyers, or people who were in the government. And so, and I was really happy having sort of an interdisciplinary education. And so I loved it. But when I was in DC, right near the end is when the Monica Lewinsky scandal broke, and there was just so much where the national news was the local news that I missed Massachusetts, and I thought I'm going to go to law school back at home. So that's what led me back to Massachusetts. So I come to court after I drop my daughter off at school, and I usually clean out my emails, and then the clerk who's running the session will come and tell me sort of what our day looks like, how many cases we have on, what type of cases we have, if we have a lot of motions, if we have a lot of trials, if certain lawyers need to get out because they have to be in different courts, things like that. We sort of just have a conversation about how the day is going to go, and then the court officers will come get me when everyone's ready. I try to get out on the bench as close to 9 o'clock as I can, just because as a former DA and a former criminal defense attorney, I know that people's time is precious and they have other courts to be in. So I don't want to waste anyone's time, and if we're just doing sort of preliminary things, I'm happy to move those along quickly. So I like to get out on the bench. We generally do the first call. I try to get rid of most things that just need dates or things like that. If anybody answers ready for trial on a bench trial or a motion to suppress, I'll just put it on for a second call, because I'll try to do that when most people are gone from the courtroom so they don't have to sit there and listen to it. Statutorily, the restraining orders are supposed to be called first, so my clerk usually pre-calls them to see who's here and who's not. If people are here with lawyers, I know that's going to be a longer hearing than people who are what's called pro se, meaning you're representing yourself, or if there's just one party here. So after the first call, I try to finish the restraining orders, and then I usually get off the bench for a little while so that people can have conversations. A lot of times the attorney will say, we're trying to work this out, I need to talk to the DA, or the DA won't know if they're ready for trial because they're not sure if the witnesses have showed up, so they need a second call. So I get off the bench for a little while. Usually at that time, I work on whatever I'm writing. So if I've heard a motion to suppress or I've heard a civil case and I need to do writing on it, I'll work on the writing, waiting for them to have me come back out. The day is 8:30 to 4:30, so I try to take the bench at 9. We take lunch and recess from 1 to 2, and then pick up matters again at 2 o'clock.
What are your top 3 favorite things about your job?
Wow, that's a really good question. I love everything about it because I was on both sides as a prosecutor and a defense attorney, so I love being in the middle now, and I like being able to help people adjudicate and come to the middle, usually. I love district court because my purpose as a district court judge is both to punish and to rehabilitate. So I want to make sure that the victims of crimes get some satisfaction, but I also want to make sure that the person who committed the crime, if it's a substance abuse disorder or a mental health issue or something like that that gave rise to the criminal conduct, that we're able to address that and help them with that so that hopefully they don't come back into the system. So I think that's the best thing about the job. A lot of people, when I was applying to become a judge, said, how come you don't want to be a Superior Court judge? Because I practice a lot in Superior Court. And once you get to Superior Court, sort of the time for rehabilitation is over. You've either done, or you're accused to have done something very serious, or you've maxed out on your district court time and now you're just going to go do state time. So the sentencing guidelines are a lot stricter, judges have less discretion, and the time that people spend in state prison is a lot longer and a lot more serious. So there sort of isn't that opportunity to try to change someone's life and give satisfaction to the victim.
If you couldn't be a judge, what other career choice would you make?
Wow, that's also a good question. This is going to sound really frivolous, but when my daughter was younger, I really liked organizing her parties. And so I think I would be a really great party planner for kids. I think also I would have probably gone into politics. I would have liked to have been a representative or a senator in some capacity or in an executive function, because I love the law. I think that policy can really change people's lives for good. So there's the frivolous, and then there's the more exciting.
Have you ever lost sleep over deciding on a verdict?
Not necessarily a verdict, because most of the cases go to jury trial that are trials, and so that's on the citizens of Middlesex County to decide. On bench trials, usually defense attorneys only elect a bench trial if it's a legal issue and they want to put it before me, or they know that the Commonwealth probably can't meet their burden and they just want it to go faster. So most bench trials are not guilties because of the nature of the facts that give rise to the charge. So not really a verdict. Sometimes I agonize over questions of bail or revocation when I know that I am taking the person off the street, away from their family, if they're the breadwinner in their family, if I know it means their kids aren't going to see their parents, if it means that it's going to disrupt other people's lives. So the collateral consequence of holding somebody in jail pre-trial is deeper than just the question of whether or not that person needs to be held. The other thing that I find really hard that I didn't think that I would as a judge are both restraining orders and harassment prevention orders. Restraining orders are between people who are family or household members related by blood or marriage or in a serious dating relationship, and harassment prevention orders can be between people who don't have those relationships. So most of the time we'll see neighbors or people who work together or things like that. And those questions about removing someone from the home and giving them a restraining order initially based on what one person says is very tricky, because when I first got on the bench, I had a few situations where the plaintiff, the moving party, would come and say, I'm in fear of this person and here's why and here's what happened. And you have to assess their credibility, which there isn't a lot of information you have at that point except for what this person is telling you. And the standard is low, it's preponderance of the evidence. So you can issue an order and that makes the defendant leave the home, not be able to contact their children, not be able to pick their kids up from school. It completely disrupts their life. Just on that person's word. And at least 2 or 3 times since I've been on the bench, the person has come on the 10-day date, the defendant, because that's when they're allowed to be heard, with videotape evidence that it was actually the opposite, that they were the person that was being screamed at and abused. And so that's hard, because I know that I'm making a decision at that moment that's going to completely disrupt this person's life. And even if I don't continue the order, there's always going to be a restraining order on that person's record, their criminal record. And there isn't really a way to get rid of that. And that can have adverse effects on people's lives. And we sort of run on a parallel track to the probate court. And so some people use the restraining order in the district court session to get leverage in their divorce. And so we get a lot of those, and there isn't a lot of information as much as in a trial or another place where I would be able to look at volumes of information and be able to make an informed decision. You sort of have to do it quickly. It's on an emergency basis, and it really hinges on that person's credibility at that moment, and that's the only decision that you're making. So I agonize over those. The other issue with the harassment prevention orders is that you get the benign where somebody's mad because their neighbor's blocking their driveway with the trash cans, or you get somebody who really is being stalked by some guy who's in their chemistry class that they don't know, who's following them home on the bus and things like that. So some people come in with those orders, and every time I see them, sometimes my initial reaction is, and then because you hear all these things that don't rise to the level of the statute, and then you'll get one and you think to yourself, wow, that's really scary. This person needs to be protected. So it's not really verdicts, it's more with the restraining orders and harassment prevention orders where I sort of have to step back, take some time, and make sure that I'm doing the right thing.
Is there one case that has affected you the most?
I think when I was a prosecutor, I was the domestic violence prosecutor for probably 1.5 years, and I was only 26 years old at the time, and sort of came from a sheltered background, and I didn't really understand a lot about domestic violence. So at first I would get frustrated because I would meet with the complaining witnesses or the alleged victims in the case, and most of the time they were women, and they would come and they would tell me these horrible stories about the level of violence in their relationship, how it escalated, get all this information from them, get ready for trial, and they wouldn't show up at the trial. Or they would come to the trial and take the stand and deny everything that they had told me. So I would give an opening statement and the jury would be there and I'd be ready to go, and then your case just falls apart in front of everyone. And my first reaction to that would just be so frustrated until I learned all of the other things that are going on in these people's lives. So I'm just gonna say women by way of an example because it's easier, but obviously domestic violence, there's no gender bias, it happens to anyone. But you never know what's going on in that person's life. So they're summoned to court. They know that they're subject to arrest if they don't come into court. But if they're there in front of the person they were in the relationship with, who's the abuser, they may be an undocumented immigrant and they don't want to get deported from the country. They may be a stay-at-home mom who doesn't have any money outside this situation, and so if she sends them to jail, how's she gonna live and support the family? She may be concerned about retaliation by him afterwards if he just gets probation and not a jail sentence. So there is so much more going on in these people's lives than what my job at that point was to prove the case beyond a reasonable doubt. And so I think being younger and growing up in a situation where I was lucky that I didn't see that in my own family. And then again, I think it's becoming sort of more okay to talk about violence within a family system or other people. It was not like that when I was growing up. So I didn't know if I had anyone in my community or my church or my school that was suffering from the situation. So coming in, you really need to think about where these people are coming from. One of my first case when I became a criminal defense attorney is I was on duty in Air District Court, and there was a young kid, he was 23, he was on probation for an OUI, which is a drunk driving case, and he didn't have that bad a record, except he had gotten indicted when he was really young, 19, for breaking and entering into a bunch of people's houses. He and his friends had a severe drug problem, and so they were breaking into their neighbors' houses and taking their TVs and selling them in order to support the drug habit. So he had a long Superior Court sentence over his head, and he was driving his car in my case, in the new case, out in Gardner, and he wasn't drunk. It was the middle of the day, and there was an old lady that stepped off the sidewalk, but she didn't go in the crosswalk. She just stepped out into traffic, and he hit her and he killed her. So he was charged with motor vehicle homicide. And I read the police report and went down to see him because he was in custody. And after I read the police report, I said, oh, you should totally try this case, because the driver behind said to the police, if he hadn't hit her, I would have, because nobody knew that this woman was gonna come out. So he hired me to defend him, and my husband said only your first defense case would be a motor vehicle homicide, which is obviously more serious than, so I had to get an accident reconstructionist, and we went through the whole thing, and it was 3-day jury trial out in Fitchburg District Court, and the judge was all excited about the case, so he got a bus and he wanted to take the jurors on a view of the intersections. We all had to get on the bus, and then he wanted to buy the jurors coffee after. So we're in this little coffee shop, and on the front page of the local paper was everything about this case, because it was the biggest case that there was. So I'm trying to stand in front of the newspaper so that the jurors can't see it. But we got to the site, and it was such an inherently dangerous intersection that the town actually tore it up and changed it afterwards. But when we were there were almost 2 accidents while we were there because it was just such a bad scene. But the thing that was very stressful for me is that he was innocent. So it's not that he was not guilty or that I was just putting the Commonwealth to their burden. He really did not mean to hit this woman, and he was so young, and his girlfriend, and he had a baby on the way, and he was definitely going to get the suspended Superior Court state prison sentence triggered, and then he would have spent the rest of his young adulthood in state prison. So that was a very stressful, and I had never had that because I had never been a defense attorney before, so all of my concern were whether or not I was going to be able to send the person to jail and answer to the victim's family. And I had never had his parents died when he was young, and so his grandparents raised him. So his grandparents were the ones that were in court every day, asking me questions, wanting to know what happened, hoping that I could guarantee them. And there's no guarantees in criminal litigation. It's inherently unpredictable, and so that was very stressful. Luckily, he was found not guilty, so that was good. But after that, I was thinking to myself, I am not cut out for this line of work anymore, to be the person where I feel like it's on me. Yeah. So that case was really hard because I got hired when I was 8 months pregnant with my daughter, and the case went to trial in May, and she was only a few months old then. And the trial was the Monday after Mother's Day. So my first Mother's Day, my husband took our daughter down to his parents in Rhode Island because I needed to trial prep and I couldn't have, sort of the distraction. It was hard. It was good at that point in my life because I could make my own hours. And I was lucky with our parents. So we had, our sets of parents would take Lizzie is my daughter's name, on different days of the week, and then I just wouldn't be in court on Tuesdays, Thursdays, and my husband would have her Wednesdays and things like that. But it was very difficult early on because as soon as she went to bed, I would do all of my work. And at that point, I was doing a lot of appellate work too. So at 3 a.m, I was writing these briefs, and it just becomes difficult. But I think it's like that with every working parent. It's just about juggling and what you can do and how you can compartmentalize. So, and the same thing is with my job here. When I leave here, I'm used to coach our softball teams or, on the PTA and all that kind of stuff. So you just sort of have to leave it. But there are some days when I make decisions or I know something's coming up where it's sort of always in the back of your mind.
Do your political beliefs influence your verdicts?
So no, but I think that's because I don't do federal work. I'm not in federal court, so usually we wouldn't have questions that came up with respect to that. I love the law, and so I'm very neutral on that. I think it's awesome that it's always evolving. When I was graduated from law school, hardly anyone had cell phones and only drug dealers had cell phones. So if I was prosecuting drug cases at that point, it's like, oh, they had cell phones and the cell phones were buzzing and only drug dealers carry cell phones. And this is how you can think that. Now everyone has them. 10-year-olds have cell phones. But the law is evolving now because your cell phone isn't just a phone anymore. It's essentially a bank vault, a diary, it's your family's photo album. So there's all this evolving case law about who can get into a cell phone and do you need a search warrant and what do you have to demonstrate to do that. So politics doesn't really come into that because it's mostly about the Fourth Amendment and what the case law says. So you really don't have that in the state court situation because my job as a judge is just to apply the law to the facts. So I would sort of never have the outside situation come in. The only time that I've had that sort of recently was a local gentleman around here who had no record. He was a young man, and it's unclear to me how they came about, but a search warrant was executed for his home, and inside his home, he had an arsenal of weapons, high-capacity firearms, ammunition, Kevlar vests, and then they got a search warrant for his computer and his social media, and he was a sympathizer to the groups that were involved in the January 6th insurrection. And so my only role in that situation, the Commonwealth moved to hold him for dangerousness prior to trial, saying that there were no conditions to keep the community or anyone safe from him. So I had to go through a lot of his emails that were political in nature, but I wasn't looking at the content. I was looking at whether or not that gave rise to a feeling that his thought process and his decision-making process would affect his ability to be safe in the community. So based on the fact that he had all of these firearms, an arsenal, a lot of the communication were about rising up, and there were threats toward the government, the FBI, Speaker Pelosi, all those type of people. I could make a finding based on that actually didn't have anything to do with the political context that gave rise to it, just what he was saying, and then the very concerning amount of weapons and ammunition that he had, because if he did want to do something, he would be capable of a lot of destruction just with what he had in his home. So if you want to be a lawyer, I think that's great. There's a lot of reading and a lot of writing. So the best thing you can do is read as many things as you can and read the things that you're interested in. When I was little, my school's motto was work hard, play fair, be kind. And I think if you try to do that every day, you can be successful in whatever you want to do, but especially if you want to become a lawyer, because you really do have to work hard. If you become a lawyer, your reputation amongst your peers and amongst the judges you practice in for playing fair or playing by the rules is the only thing that you have, and that's how you'll be successful. And then you should always try to be as kind as you can to everyone when you go out in the morning, and when you come back, just do the best you can.